May it please the court. Counsel. Your Honors, my name is Grant Gangestad. I represent the appellant, Mr. Pettijohn, in this case. We appreciate the opportunity to come back and re-argue this case in light of Birchfield, or North Dakota versus Birchfield, and I promise that I won't yell in the Supreme Courtroom this time around. Your Honors, warrants are the first and best safeguard against unlawful police searches. The purpose of the warrant requirement under Article 1, Section 8 is to act as a gatekeeper, to prevent and not simply redress or remediate unlawful police action. Warrants are the rule, not the exception. Unfortunately, the U.S. Supreme Court's decision in North Dakota versus Birchfield does not honor that principle and instead favors an exception over the general rule that a warrant must be obtained prior to a search being held. Birchfield is incongruent with the Iowa Constitution for several reasons. First, it substitutes an exception for the general proposition that a warrant is required to conduct a search without any showing by the state that a warrant would be unable to be obtained in this case. It also engages in a balancing test to find somewhat arbitrarily that a search of a person is unconstitutional in one instance and constitutional in another based upon the type of evidence being sought. And third, it allows for a search under an exception that this court specifically rejected in Gaskins. We believe there's a simple fix to this. To best protect the rights of Iowans, consistent with the principles set forth in our state constitution, we would ask that this court require that an officer apply for and obtain a warrant when they're seeking to obtain a chemical test in a boating while intoxicated investigation. Now, this requires a person to comply with a warrant, which in this case would be chemical testing. However,
would that rationale apply to driving too?
This is obviously not a driving case. This is a boating case, and we believe there's obviously there is no case law regarding the implied consent procedure for boating.
Aren't there other exceptions, though? I mean, to a warrant. I mean, we got exigent circumstances. We have a consent here. We have an implied consent here. I mean, let's assume that we actually follow Gaskins and say that the search incident to arrest is not available under the Iowa Constitution to just general evidence gathering. What other exceptions are here that would allow this to happen under these fact situations?
Well, we believe that a warrant would be required under normal circumstances, absent any showing by the state that a warrant could not be obtained. Obviously,
well, you know, the exigent circumstances, we don't require showing that a warrant couldn't be obtained.
Sure,
when someone consents to a search, you know, I come to your front door and I'm a policeman and or authority and say, I want to search your house. You say, yeah, go at it. We don't require the homeowner, the police, to show that they couldn't get a warrant. I mean, so there's 31 exceptions to the warrant requirement, and a few of them may apply. I mean, do they or don't they in this case, and why not? And the exigent circumstances and consent are the two that I want you to focus on.
As far as consent goes, Justice Wiggins, I don't believe that this is a consent case. If this is a consent case, it was coerced consent based upon the advisory that was read to Mr. Pettijohn. If we're simply looking at this from a consent analysis, it's our position that implied consent started as an administrative procedure and has never truly been constitutionally validated under a true consent analysis, and it's whether or not consent is voluntary.
Let's assume the U.S. Supreme Court has rejected this implied consent as consent in these cases, and I don't know why the Iowa Constitution would do the same, but my concern is under the totality of the circumstances, whether consent. Now, if you look at a Hawaii, and I think there's a Kansas case, they'd say no, and those were in the drunk driving areas, not the boating areas. But, you know, is there consent here? Or is it coerced? And if it's coerced, or if it's not under the totality of circumstances, not knowingly or whatever, voluntary, tell me what facts lead you to believe that this consent, where he signed this sheet of paper, he was given a right to contact somebody if he wanted to, and all this stuff wasn't a good consent.
Well, in this case, obviously the advisory that was read to him stated that there was a monetary penalty for refusing to consent, also a revocation of boating privileges as well. It'd be like if somebody came up to your door and said, hey, I think you got drugs in here.
Most courts in the country in the driving context have said the revocation of your license of your privilege to do that act is not in itself coercive because it's part of the licensing procedure. So, you know, I don't know where that gets you, but under the totality of circumstances, what would you point out that would make this gentleman's consent not valid against the warrant requirement?
Under the Iowa Constitution, we would ask that there be a knowing and voluntary standard, a knowing and intelligent standard, that he knew that he could refuse, that he was never told that he could refuse without any penalty. In fact, he was told there was going to be a penalty. Further, under the standard of voluntariness, there was obviously the fact that there is that monetary penalty there, and that is in itself coercive. Some people may not have the $500 to spend in order to refuse that test and withhold their consent.
Yes, you know, Birchfield involved a criminal penalty for refusing the test. What we have in Iowa are non-criminal sanctions, and the U.S. Supreme Court in Birchfield said, nothing we say here should be read to cast doubt on them. Has any other state, to your knowledge, found that the implied consent process is invalid or constitutionally invalid under their state constitution where there's no criminal penalty being imposed?
Where there is no criminal penalty being imposed, Your Honor, I do not know of any right off a hand. However, I don't believe the analysis is any different. Under just a pure consent analysis, there is still a penalty there. There is still something that coerces consent. And like I said, with the implied consent procedure that has kind of evolved since the 50s, 60s, in reading all the cases, I don't believe there's been any court that has ever actually analyzed implied consent under a pure consent analysis. It's sort of developed into its own.
Well, the Hawaii Supreme Court has, and the Hawaii Supreme Court put a lot of weight on the criminal penalty versus, and some of the other things, and they said that was coerced, and they have a whole list of factors in there. Are you familiar with that case?
I am, Your Honor.
And the question I have is, I'm not so concerned about not being able to vote because, you know, that's not really an administrative penalty. What I'm concerned about, does the $500 to $1,000 fine compare to the criminal penalty of a simple misdemeanor like they did in Hawaii or other states where they've done it? I mean, that's the thing that I'm worried about.
Well, a simple misdemeanor in Iowa is punishable by less than $2,000. That's for certain. It's punishable by anywhere from $65 to $625, and obviously a first offense refusal here is $500. That's very akin to a simple misdemeanor, which could also be punished by jail time, obviously. But it also doesn't break it down. The advisory that was read to Mr. Pettijohn, it said $500 to $2,000, and he was not eligible to be given that $1,000 or $2,000 penalty, and it didn't tell him that. So $2,000 is more than a first offense operating while intoxicated charge, the fine for that being $1,250. The fine for a boating while intoxicated first offense charge is $1,000. So I think that's very, very coercive when you consider the penalties on the criminal side.
Would your arguments apply with equal force to driving cases on our roadways?
Again, this is a boating case, and I believe that, you know, obviously the Iowa Supreme Court and U.S. Supreme Court, you know, whether good or bad, have upheld implied consent in the driving context. And obviously, this is a boating case. We're not asking that be overturned in this case.
But I don't know. Driving doesn't have this $500 to $2,000 penalty. Driving doesn't have a criminal penalty, so it's a different analysis if you read the cases around the country.
I would agree. It would be a different analysis. I think that you know, in this case we're focusing on the boating statute, and obviously that could be potentially an argument for another day. But it's our position that the implied consent procedure in boating while intoxicated cases is unconstitutional under the Iowa Constitution. Our opinion is that a warrant should be obtained, And we believe that if a warrant is obtained, a person does not have a right to refuse that test. However, an implied consent component could be incorporated into that. Once an officer gets a warrant, the person could be given a choice. Either you can comply with this, or you can suffer the consequences, which is basically failure to comply with a lawful warrant.
How easy is it to get a warrant in Iowa?
If you read the case in State versus Gaskins, it's alluded to in Justice Cady's concurrence, as well as some other portions of that opinion, that obviously we have the first in the nation all electronic filing system. Officers can use that. They can file for warrants in their vehicle without much effort. Fillable warrant forms are available electronically that can be filled in within a couple of minutes. They could do that on their way or before they get to the station, and by the time they get to the station, the warrant could be procured. So I don't believe that there's, with the advances in technology, that there is a great concern that there is not going to be enough time to procure a warrant. Also, if you look at the implied consent statute as it exists currently, it allows the officer 2 hours from the time of the preliminary breath test or PBT refusal or an arrest to request the test. So they've got 2 hours that we're not really that concerned about the expediency of procuring the test, I don't believe, because we give that 2-hour time period in there. I believe certainly within 2 hours a warrant could be procured, whether electronically through a telephone warrant, something of that nature.
Is there anything in the record about that?
There is nothing in the record regarding how much time it would have taken to procure a warrant. This case was argued, I think, a year and a half prior to Birchfield. Obviously, we would have liked to develop that record, but certainly we believe that certainly within 2 hours a warrant could have been procured.
Is it your burden, or is it the state's burden to show?
It's not our burden. It's the state's burden to show that that the warrant requirement was either complied with or there was a valid exception to the warrant requirement. And our position here is that the warrant requirement is the trump card that you need to comply with the warrant requirement, and that in this case the search incident to arrest exception is not applicable under the Iowa Constitution. I'm going to call the search incident to arrest exception under the Iowa Constitution sort of the evil arrestee exception, where the arrestee is either trying to flush drugs, throw drugs out the window, try to grab a weapon to harm an officer. It does not apply to situations like this. In Gaskins, the court stated that use of the exception to sanction a warrantless search that has nothing to do with preventing arrestee from gaining access to weapons or evidence is an anomaly.
Mr. Sloven's response to that is that even in Gaskins, we certainly recognize the sort of the vanishing evidence problem. And don't you have that problem here because of the dissipation? And also, let's say hypothetically, it might not be that easy to get a warrant electronically. You might have to go and find a judicial officer in person to do it. Wouldn't that impact your analysis?
I think that this is an attempt by the state to get a per se exigency without calling it per se exigency. This is Lovick, and Lovick stated that there is no per se exigency in the dissipation of alcohol and blood. This is sort of the wolf in sheep's clothing, sort of the per se exigency in search incident to arrest clothing. And I don't think there's any way you can square those two exceptions. There is, in one case, you can't do something, but if you call it search incident to arrest, then suddenly we allow that.
McNeely said there is no, U.S. Supreme Court, there is no exigent circumstance per se with this drunk driving. And they said that the state needs to show the exigent circumstances exist. Is there anything in the record here that shows the state made that showing that
No,
you're
Your
aware
Honor.
of?
No, Your Honor. We believe that there was no showing by the state that there was any exigent circumstance or that any other exception to the warrant requirement applied. Again, it's our position that the warrant should first be complied with if they're able to get a warrant, and it's our position that they should have been able to procure a warrant in this case. I believe that the balancing test that the Supreme Court engaged in is kind of a slippery slope. And the Supreme Court sort of split the proverbial baby, I think, with regard to blood testing and breath testing. and believe that there is a more straightforward way to attack that, which would be requiring a warrant. Thank you.
Thank you as well, counsel. Mr. Sloven.
Thank you, Mr. Chief Justice. Counsel, may it please the court. Good morning. I want to start by talking about the worst case scenario. Even if invoking implied consent here, or even if this kind of a search, a breath test required a warrant normally, even if this were approached the same way that Birchfield approaches blood tests, that would invalidate a criminal penalty imposed for a refusal. That would not invalidate the state's invocation of implied consent. Birchfield very clearly stated that, and it reiterated what was said in McNeely, that nothing about saying that there's no per se exigency there with the dissipation of alcohol in the bloodstream, nothing about that invalidates implied consent frameworks.
I think that's just wrong, because a civil penalty, I mean, there was some discussion about this already, is a civil penalty versus a simple misdemeanor. You know, you're making a formalistic distinction. Well, one is criminal and one is not. But that strikes me as a little bit odd. I mean, the argument is that if the civil penalty was $10,000, well, it would still be voluntary because it's a civil penalty. If it's $1 million, it'd still be voluntary because it's still penalty. In fact, the civil penalties associated in this case are kind of comparable to a simple misdemeanor. They don't have the exposure to jail time that a simple misdemeanor might have. I mean, that's obviously true. But I'm not sure that this distinction between criminal and civil makes a lot of sense. Help me there.
Well, I would also point out that it's comparable to the civil penalty imposed for a refusal in the driving context, that there's a $200 civil penalty imposed. That statute actually carves out exactly where that money goes. The boating while intoxicated statute does not do that. But I think that there is a difference there because it's not a criminal penalty imposed. It might just, it's partially in the wording, but it's also in the act that triggers the imposition of that civil penalty.
And doesn't Justice Apple have a point that, although the U.S. Supreme Court has drawn this bright line between criminal penalties and civil penalties, we're not bound by that line under the Iowa Constitution, and it's not entirely clear what is the rationale of that line. So help me, what is the rationale? What's the reason?
So I think the rationale is that it's attached to the revocation of the consent that's imputed to everyone, whether they're driving a car on our highways or operating a motorboat in our waterways, imputed to everybody who takes part in that system that inherently creates a risk to others. So by revoking that consent, right, that puts it in the realm of a regulatory measure for public safety, that consent is part of these essential safeguards that make sure that you can drive on our roads, you can use our waterways without fear of...
But the revocation of the license has a nexus to that. You know, if you're not going to do it, you're not going to drive. The revocation of the right to boat has a nexus to that. But when you talk about the additional fine, and the $200 in the driver has a nexus because it goes to driver safety. But when you look at the nexus between the $500 to $2,000 penalty, I don't know how, and help me out here, Hawaii and some other states went through the analysis. That's enough to put it over the top under their state constitutions. Why isn't that enough in Iowa to put it over the top? But there's no nexus between that. It's just a coercive tool to say, take the test or pay.
Well, so I think that it's you label it coercive there. I don't think that that's the right term. I want to return to a question.
Well, Hawaii said it was coercive. I mean, why isn't it coercive?
Sure, and I think that it can have a deterrent effect without necessarily being coercive, to know that the next time we'll have will involve the same penalty if I subsequently boat and refuse to consent to that test. And I think that there's the statute doesn't tell us exactly what purposes that civil penalty is used for.
What if it was a $100,000 fine? I mean, the legislature could make it a $100,000 fine if you don't.
I mean, I think that we can evaluate the coerciveness of that if we choose to do so under the totality of the circumstances. I think that the totality of the circumstances in this case indicates that there's no coercion present. And I don't think that attaching a dollar value to this, I don't think that we can say that that's coercive in a way that a normal civil penalty isn't.
In reading your brief, I want to back up a second because we're getting ahead of ourselves here. In reading your brief, I think you acknowledge that if we follow Gaskin and we don't have the evidence gathering function, that you're going to have to go either exigent circumstances or another exception like search instance to arrest or consent or something. Do I read that right?
So what we argue in the supplemental brief, and I want to be clear that to the extent that error preservation is brought up, I don't think error is preserved for any argument that would apply equally to boating and driving, that the original briefing here was entirely about boats. The appellant conceded repeatedly that implied consent is constitutional in the context of driving.
We can agree we're dealing with boating, but I think you said in your brief that if we follow Gaskins and apply that to boating, that search instance to arrest cannot be a general evidence gathering function.
So
under the Iowa Constitution.
So I agree that what Gaskins said is we still have officer safety for search incident to arrest. We still have evidence preservation. We don't have straight up evidence gathering. But I think Birchfield makes it very clear that a breath test incident to arrest in an arrest related to an intoxication-related offense is about evidence preservation more so than evidence gathering.
But that's only if there's exigent circumstances of the dissipation. And what evidence has the state presented? I'm sure you agree that the state has the burden to show a warrant wasn't needed. And what evidence did the state present as to dissipation and as to not be able to get a warrant before dissipation in this record?
Now, here's the difference, I think, between search incident to arrest and the normal exigent circumstances exceptions is that search incident to arrest applies categorically. There's no need for an independent showing when you arrest somebody of, here are the exigent circumstances that required me to do a pat-down search. Search incident, and this comes through very clearly in Birchfield, that it's a categorical exception, that anytime you make an arrest for an intoxication-related offense, you can breath test the arrestee. And if we did need a case-specific exigency showing, we could do that very easily just by explaining the natural process through which alcohol in the bloodstream is filtered out and metabolized. That evidence is disappearing every second that goes by after the arrest, and the breath test is a very non-intrusive way to preserve the evidence of intoxication.
But that doesn't strike me as quite right, and here's why. The search incident to arrest is in fact based upon you can't practically get a warrant. I mean, here's the defendant in front of you. You're concerned about officer safety. You're not going to say, "Let me get my cell phone out. Hold on." You know, I mean, it's an immediate thing, and I gather there's unanimous agreement on this court and elsewhere that when you're patting down somebody for potential weapons, you can't get a warrant. And you might find drugs or something within arm's reach that could be destroyed. And once again, you can't kind of freeze them in ice while you go get a warrant. That's all true. But on the issue of evidence gathering, it's not clear. It kind of depends. It depends on the facts. So with respect to evidence gathering, since the state has a burden, doesn't it have the burden of showing that, in fact, a warrant was impracticable? I mean, you got to concede it with respect to officer safety, and you got to kind of concede it with respect to possible destruction of drugs. Warrant's not practicable. With respect to with respect to dissipation, why doesn't the state have a burden of showing factually that this was a problem?
So I think that the answer is contained in that question, right? That when you do the pat down, you don't need to apply for a warrant, and it's not necessarily because you can't, right? You could arrest somebody right outside the courthouse. We don't require the officer to testify that it was impossible for me to get a warrant before performing that pat down. It's but categorically accepted as a kind of search that we can do.
Sure,
that's
and I accept this categorically because common sense tells us it's not possible. I mean, you can't get a warrant prior to a pat down. But on exigent circumstances, with respect to evidence gathering and whether there's going to be dissipation or not, I think there's substantial factual questions there. On the pat down for weapons, I mean, it's almost you call it categorical. It's almost a conclusive presumption, and I get it because I think, yeah, I mean, yeah. But on the issue of evidence gathering, it's not at all clear to me that in this particular case, going getting a warrant would impair the evidence gathering activity. The record doesn't say one way or the other, I don't think.
So I guess there's two responses to that. The first is that I think this is still evidence preservation, and the categorical aspect to this is that alcohol metabolizes in the body. The evidence of intoxication disappears. But then second, and this came up in Mr. Gangstad's argument.
But didn't McNeely put an end to that one, that it's not categorical when you deal with dissipation? It's based on the facts and circumstances.
Well, and this is something we tried to highlight in our brief, is that in our supplemental brief, is that, look, McNeely said there's no automatic exigency, and State versus Lovig is still intact. But what Birchfield said is that when you make the arrest for the intoxication-related offense, then you can preserve that evidence, right? It may not be a per se exigency justifying a search independent of arrest, but when you have the arrest for the intoxication-related offense, then it is a reasonable search to prevent the inevitable, automatic, already ongoing dissipation of that evidence. And that is the critical evidence resulting in the arrest. So it's inherently reasonable to use a very non-intrusive procedure to preserve that evidence. Now, I also want to talk about how reasonable it is to get a warrant. And the record is just entirely devoid of adjudicative facts that could help us make a decision about that.
Isn't it your burden to show that a warrant is impracticable? In order to invoke most of the exceptions to the warrant requirement, I would say all the exceptions, you have to show that obtaining a warrant is impractical, and you haven't shown that.
So it has never been the state's burden to show obtaining a warrant is impractical before invoking implied consent. That this is something that we impliedly consent to when we use the highways, and in this case the waterways, and we don't need to show it was impracticable to get a warrant for the state to rely on that imputed consent, right? And then to ask the driver to follow through.
Outside implied consent, you would agree with me, I take it that it's the state's burden.
Outside of implied consent and outside of some other valid consent or warrant exception, then yeah, I would agree with that. And I think that, so I want to return to the facts in this case. Justice Wiggins, you asked about what do we know about the decision in this case and whether it was voluntary. We do know a few facts. We know that the defendant was 31 years old, displayed no lack of understanding when the advisory was explained to him. He had 3 prior OWIs, so prior experience with implied consent in the criminal justice system. We know that there was no mental subnormality alleged. This was a very short detention and investigation.
I understand, but how do you distinguish it from Juan, State versus Juan? I don't know how to pronounce the Hawaiian. Where they went through the same analysis. He had the same things we went through, and they said that the thing I think they said put over the top was the criminal penalty. They were in custody. They were told of if you don't do this, you're going to have a criminal penalty. Here you're told you're going to get up to a $2,000 fine. How do you distinguish the analysis in one from this case?
So I think where Juan went wrong is by characterizing that penalty as inherently coercive, that the fact that there is a monetary penalty or other penalties associated with refusal makes it coercive. And it was discussed during Mr. Gangstad's argument that no court has ever really analyzed this to see if this is coercive. I don't think that's true. In our initial brief...
In Pals we did. We said sitting in the backseat of a car after the stop's over was inherently coercive. I mean, we've come to that conclusion before. And how is this any different than Pals and Ones combined?
So I think it's very different because this is a situation where, well, so first I just want to point the court to pages 24 and 25 of our initial brief, cases analyzing implied consent and determining whether those penalties for refusal are coercive. To distinguish this from Pals, this is, I mean, it is unpleasant, and it's not a situation you would choose to be detained and being investigated for OWI or boating while intoxicated. The fact that you're confronted with an unpleasant decision doesn't make it inherently coercive. It doesn't in the context of plea bargaining. It doesn't in the context of entering a guilty plea.
Yeah, I'm going back to our earlier oral argument, if you don't mind, but I mean, that's like saying you knock on the door, I'd like to search your house, $500 fine, do I have your consent? And, you know, I think that's troubling, isn't it not? And
Sure, and I think that for good reason we don't have that statute. What
well,
we do
but
have
it-
is,
But are you saying it'd be constitutional because it just puts you to an uncomfortable choice?
I think it would be, I think that that's a different situation where the
How is
state,
it less coercive? Is it coercive? I mean, let's say we had a $500 fine if you didn't consent, knock on your house, I'd like to search your house, $500 fine. And the only issue raised was coercion. You would say, no, it was a voluntary choice?
Your Honor, I'm out of time. Thank you. So I think it's very different because cars don't exist in the same context. That
But would you, I mean, I'm just
Or
kind of
boats.
curious, would you say that was a voluntary choice or not a voluntary choice? In my $500 fine, knock on the door hypothetical?
I would say that if the penalty that's threatened to get the consent is something that the state cannot do, then I suppose that there is an element an element in there that could undermine the voluntariness of the decision. And I think that this court would probably look at that as threatening a penalty for the exercise of a constitutional right. But there is no constitutional right to refuse the breath test after an invocation of implied consent. It's a statutory right, and this court, in all of its implied consent cases, has reaffirmed that.
Thank you, counsel.
Thank you.
Rebuttal?
I'd like to briefly discuss what Justice Appellant and Mr. Sloven were just talking about. I think Mr. Sloven said something to the effect of, if it would only be coercive if it was something the state couldn't do. But we could create any statute saying or purporting what the state can do, but it's whether or not those statutes would be constitutional. I think the focus is wrong in that argument.
It might be wrong on the totality of circumstances argument, but what about he's kind of relying, I think, on the implied consent argument, which is a kind of a curious legal creation, I guess. It may well be that under Schenkloth, a $500 fine or $200 fine or some fine is a coercive element, but does the analysis change when we take a look at implied consent?
Again, Your Honor, it's my position that implied consent it's a legal fiction. It is not real consent. Just because you call it implied consent does not mean that it's consent. And I think the state is sort of relying on implied consent as its own sort of kind of out there exception on its own. And when we talk about the exceptions to the warrant requirement, implied consent is not one of them. Consent is one of them, but not implied consent. And I believe that's a really important distinction. If we want to call it consent, it's consent. If it's not, it's not. Here there's definitely coercion. There's a penalty. There's a voting revocation, and those things are they weigh into the consent analysis. And Justice Wiggins, I'm glad you brought up State versus Pals, because obviously that is our consent framework in Iowa. Mr. Pettijohn was in custody. He was under arrest at the time. He was taken off-site to the Polk City Police Department, and he was never told he could refuse without penalty. In fact, he was told he was going to be penalized if he refused to submit to that test. I think it's also pertinent that under the implied...
Now, if they didn't have the $500 to $2,000 penalty, would your argument be the same?
Yes. If you look at the consent factors in PALS, I think it lines up pretty well with that. Again...
But there is not a court in the country, I don't think, that has struck down implied consent on that basis alone without implied consent plus something to coerce you to consent.
You guys could certainly be the first.
If we were, counsel, what would happen to the state's ability to protect boaters from, a lot of people die in drunken boating accidents. There's a holocaust on our waterways just as there is on our highways from drunken driving. What would be the consequences if we did what you are asking us to do?
Again, I think that we can save the ability to obtain tests if we get a warrant and then have that implied, sort of what I'll call an implied consent component after a warrant is obtained. We can say, hey, you can either consent to this, which you are constitutionally required to do, or we'll give you the right to refuse it, but we're going to penalize you for it. Then I think then it makes constitutional sense and it passes constitutional muster. As it is right now, there is no exception that is valid to uphold this. It's got to be, if it's going to be consent, it's got to be valid voluntary consent. The other way the state could obtain a test is simply ask the person, would you submit to a test, without trying to coerce them into taking the test. I think, if we have that, we're going to be able to have a neutral, detached magistrate make a determination before a warrant is issued. And if the legislature were to so choose, after a warrant's obtained, they could grant that statutory grace to allow somebody to refuse the test with a penalty.
You represent drunk drivers as well, or people accused of that. If you win this case, are you going to be back pretty soon with a challenge to the OWI roadway implied consent laws?
I don't know. That depends on how you guys decide today. No, I'm kidding.
The issue here is whether a warrant is required when obtaining one is practicable, I take it.
That's correct, Your Honor.
Okay,
I think that
so if a true exigency is shown where a warrant cannot be obtained and the police and law enforcement meets that burden, that's a different story, I take it.
I believe so, Your Honor. I think the real question here is whether or not the warrant requirement was met, which we are of the position that the warrant requirement is the trump card, like I said earlier.
Yes, this, in terms of this issue about whether there was sort of a case-specific exigency here, am I correct that basically as the case started, you conceded the validity of implied consent as to driving, but you said boating, waterways are different. So at that point, there would have been no reason for the state to develop any case-specific evidence on exigency, would there?
I see I'm out of time, Your Honor. May I answer? It's still the state's burden to prove that there was ability to get a warrant and that a warrant was complied with.
But statutes presume constitutional, and if you don't attack a statute on a basis, does the state have to come in with case-specific evidence showing the validity of the statute on a basis you haven't challenged?
Well, I think the only basis that they were using to uphold the test in this case was implied consent, or the ability to get a test under implied consent. And it's been our position that whole framework under the boating context is unconstitutional. Obviously, we don't have a driving case here, and we did acknowledge that courts have upheld the implied consent procedure as it relates to as it relates to driving.
Thank you, counsel.
Thank you, Your Honors.
State versus Pettijohn is now then submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.